Semester in practice. Tonight we have Professor Josh Blackman. He is a professor of constitutional law, among other things, at the South Texas College of Law in Houston. And he's probably the most published person writing legal scholarship these days. Go on SSRN, and he has like 95 different articles out there. Slight hyperbole on my part. Today he's going to make a presentation on big data and ethics. And following that, there'll be a Q&A, and also joined by him, Professor Ikes, who does e-discovery, among other things. And so she also is versed in this area. So give it up for him, folks.
Thank you so much. This is my first time in Vermont. I've never been here. Thank you. Do you have an Aggie here? What are you doing here? Why are you not in Texas? There's no rebel. You're a rebel.
Well, now we know how you feel about being in Vermont.
Well, I was informed there's a compost toilet. I don't know what that is, but I went to the other one. I didn't want to fall in. Bernie might get me. So it's a pleasure to be here in Vermont. I was earlier today in Rhode Island at Roger Williams, and it's very rare you can have 4 states in one day. But we did Massachusetts, Rhode Island, Vermont, New Hampshire in barely 4 hours. In Texas, you drive 4 hours, you go nowhere. Where are you from? Houston. Houston? Oh, you got a fellow Houstonian. Houston also? Look at this. We have more Houstonians people. Houston?
No, I'm from Chicago.
Okay, Chicago, okay. So the topic today is a timely one, right? Many of you may have seen testimony today from Mark Zuckerberg, the creator of Facebook. And I might be dating myself, but I was actually in college when Facebook was first created. You may not know this, but when Facebook, it was in 2004. When Facebook first came out, it was only available to college students. And initially, it was only available at certain colleges. So you first had at Harvard, then at Yale, and then I went to Penn State, not so good of a college. Eventually came to Penn State, and you have innovations. You had a profile picture, right? And then you had a profile of information. You could have interests, and you had groups, you had the chat. And as these features developed, most people gave very little consideration to the fact that they were giving lots of their personal stuff up for absolutely nothing in return, right? They get the camaraderie of friendship, but they were sharing this information for no monetary value. And then Facebook opened up to non-law students. And this was considered a very controversial movement. Pedophiles, stalkers, but it was open up to everyone. And now here we are, about 15 years later, and you have this Facebook president, not much older than me, testifying that his product that has billions of people connected using information. And why was Zuckerberg's testimony so important? It's not because people put up pictures of their cats or put up pictures of their desserts, right? That's not why they're there. It's that the information people were sharing with Facebook can then be used to profile them. The information people share can develop a profile that if you like this book and you like that movie, it means you might like this restaurant. And we're going to target advertisements to you. But this wasn't only about targeting advertisements of a commercial nature. It involved targeting advertisements of a political nature. Specifically, this firm, Cambridge Analytica, right? Cambridge discussed how your profile reflects who you're likely to support as a political candidate. And they can target ads that are trying to mess with your mind. That they send certain messages to certain groups on site that perhaps go one way or the other. Okay? And this is a perfect segue to the talk I want to give you today. You may all think that you are very individualistic, even in Vermont, right? You're all rebels, right? My Aggie friend. But for the most part, we're not. People are fairly predictable, and they behave in predictable fashions. And given enough information about you, big data, the cloud, can predict with some sophistication what you're going to do, what movies you'll watch, what restaurants you'll go to, what products you'll buy, what sort of advertisements will be effective on you, who you're going to vote for, right? Who you're going to marry, who you're going to swipe right for, right? These are all things which can be ascertained. My talk today focuses on one area that is very, very, very germane to law students. Predicting the behavior of courts. And in particular, predicting the behavior of the United States Supreme Court. And believe it or not, the justices are people like everyone else, and they have patterns. Now, fortunately, the justices are not putting information on Facebook, right? Maybe they are, I don't know about it. But they write decisions, and they cast votes. And by studying carefully how a justice casts a vote in a given case, you can build up a profile of that justice. And you can understand how that justice will likely vote in similar cases in the future. And this is the enterprise of law. You may never have thought about it, but why are you all in law school? What are you all doing here, right? Why are you reading all these stupid cases and these stupid opinions and these dissents? Why are we making you do this? So one day you can tell your client, here's the facts that you have, here's what I predict the court will do, here's how we should proceed. Over 100 years ago, in the common law, the path of the law, Oliver Wendell Holmes wrote, quote, "The object of our study, then, is prediction. The prediction of the incidence of the public force through the instrumentality of the courts." What does that mean? What all of you are in law school for is to try to predict what will happen in a given case. Now, most lawyers who make predictions do it based on their own brain, which is not a bad system. In fact, your brain is superior to computers in a lot of respects. You say, well, you know, Judge Smith ruled in case X this way. The facts here are similar. Therefore, case Y will turn out in a similar fashion. Come on in. Or, Judge Jones ruled a different way. But this case is different, so we'll go along here. The entire process of distinguishing precedent, you never thought of it this way, but you're trying to say, based on past performance, what will a court do in the future? And this isn't only courts. It affects administrative agencies, mediation, and all manner of dispute resolution. Because you're saying, based on what happened before, given these facts, what will happen in the future? Right? That is the basic enterprise of law. That is what you're all trying to internalize. Professor Ives and Goodenough will teach you past law, then you go forth and conquer and figure out how to apply this for the future. Okay? That's your job. My contribution is not to teach you law, not for today at least, maybe another time. Sure, I'd love to come back, it's beautiful out here. Maybe it's a little warmer, but it's still My contribution today is talking how technology can be used to predict the outcome of cases. Now, I didn't invent this. Not by a long shot. The notion of using computer programming to predict the output of cases has been around for decades. Harold Spaeth, a very famous political scientist, wrote a piece in the 1970s where he wrote a program in Fortran, that can predict the outcome of certain types of criminal law cases, and it was pretty accurate. Later on, Jeffrey Siegel in the 1980s wrote a paper on how you can predict probabilistically the outcome of various cases. In the early 2000s, another paper called the Supreme Court Forecasting Project that actually developed an algorithm to predict the outcome of Supreme Court cases. And then I got in the scene. My warm introduction said I'm the most productive person ever, not even close. But one of my earliest papers is one of my most favorite papers. And it concerns a little thing I created called Fantasy SCOTUS, which was the first prediction market for the Supreme Court. I created this as a joke, and I mean that. It was a joke. I was clerking in Johnstown, Pennsylvania, which you may have never heard of. It actually looks sort of like this. It's sort of a rural place in the Valley of Mountains. It's a beautiful place, but nothing really nearby. And I was clerking, and I was pretty bored. And the Supreme Court had, you probably understand what I'm talking about, not much to do, right? So be creative. So the Supreme Court heard a case called Citizens United. Probably heard of it. This is about campaign finance reform. Again, I'm not teaching Colin today, it's for another time. And this was a big case, very big case at the time. And a friend was on the phone, we were talking, joking, he's like, hey Josh, what do you think the odds are in Vegas on the court striking down the McCain-Feingold law in Citizens United? And I was like, I don't know, is there a Vegas line on Supreme Court? And there wasn't. and said, wouldn't it be funny if there was like a fancy leak for the Supreme Court? He's like, yeah, haha, Josh, that'd be funny. I'm like, wait a minute. Huh. A fancy league for the Supreme Court. I was like, okay, I'll build it. And that was it. I basically decided this on basically 5 minutes of thought. And I registered the domain, fantasyscotus.net. Someone actually had fantasyscotus.com. I don't know why, but it was taken. Okay, it's still taken. Still trying to get it. But I bought fantasyscotus.net, and I built it. I had a background in web development. I used an offshore developer for like $300, built the entire thing. And it blew up very quickly. Within 24 hours after I launched it, like 1,000 people sign up, went viral. I had $0 marketing budget, not even a penny. And this was in November of 2009, the early days of Twitter. Twitter wasn't even a big thing back then, right? There were barely hashtags at the time. But I launched this, and I started to think about it, right? I had thousands of people making predictions on the Supreme Court. And I realized, crap, this is a valuable asset. And my colleagues, Corey Carpenter and Adam Aft, said, we can actually leverage this. We can harness this to make a model, right? We can make a model of predictions, okay? And Fantasy SCOTUS, as it was called, became a model of crowdsourcing, okay? In later years, I would partner with Dan Katz, who's now at Chicago Kent, and Mike Bomarito, who's with Michigan State. We were a part of a group called Let's Predict, and we built an algorithm for predicting cases. But first off, in my infancy, I said, let's use the wisdom of the crowds. Okay, now what is the wisdom of the crowds? Example. There's a jar here, right? With pieces of chalk. How many pieces of chalk are in this jar? I don't know. I can make a guess, maybe 40. If I ask everyone in this room, and I average together all of your answers, I promise you, it's more accurate than my guess, right? The idea is, if you ask a lot of people their opinions with a wide range of options, you get to the right result. Not precise, but it's better. If you can harness the wisdom of this crowd, and we have 50 people here, if I ask each of you how many pieces of chalk are in here, your answer will be pretty good. So my colleagues and I said, how do we leverage the wisdom of the crowd for the Supreme Court? We looked at how the aggregate. If 100 people say that Justice Kennedy will vote in a certain way, that's probably a good indication that he will. Not certain, but it's better than asking one expert. And our league has presences across the country at all law schools. I don't know, anyone in Vermont playing? Yeah, there we go. Bravo, well done, well done. And the game is strikingly simple. Okay, the game is very simple. In any given case, you have 9 justices. I'll have to replace Justice Scalia, but I'll do that next go around, right? Miss him, still miss him. So in any given case, you have 9 justices. Justices make a choice. Do they affirm the lower court, or do they reverse the lower court? You have sometimes recusals where they step aside, but the game's pretty simple. But by leveraging this, we can get a really sophisticated database of prediction behaviors. And we've been running this since 2009, so we're basically, 9 years around, almost a decade, of thousands of people predicting a case. There is no other data set like this in the world, and I mean that. Dan, Mike, and I, we've been touting this. We've gotten some pretty significant interest from publication. I built this as a joke, but it's now developed into a legitimate social science enterprise. And it's been covered everywhere: New York Times, Wall Street Journal, CNN, ABA, Yahoo News. And more recently, whenever a big case is coming up, I get the calls. Josh, what's going to happen, right? 538, Nate Silver. Hey, it's not Nate Silver, it was Minions calls it, but 538, Josh, what's going to happen, right? U.S. News, ABA Journal, CNN, right? What's going to happen? And remarkably, we're starting to get recognized as an alternative to the experts. I mentioned a few minutes ago that there was a paper done in the early 2000s called the Supreme Court Forecasting Project. And what they did was they asked a group of experts, how will the court decide cases? And they asked their algorithm, how will the court decide cases? Their experts did pretty well, right? These are people who practice for the Supreme Court, law professors, right? partners at law firms, etc. I'll tell you something though. Our crowd beats their experts. I said it again, make it very careful. Crowds will beat experts. Why? Because experts generally focus on one specific area of the law. They can't know everything. So let's say you're an expert in criminal procedure. You might know nothing at all about tax law, right? Let's say you're an expert in tax law. You might know nothing at all about the First Amendment. The benefit of crowds is you get the entire bucket of chalk. You get the full range of human experience pouring themselves into a single marketplace. And that is why, case over case, we will beat any experts. In fact, you might be familiar with a guy called Tom Goldstein on SCOTUS blog. A very famous blog about the Supreme Court. A couple of years ago, Tom posted predictions for the last cases of the term, maybe 10 cases or so. And I was like, okay, challenge accepted. And we beat him, right? This is a guy who gets paid hundreds of thousands of dollars for a single case at the Supreme Court. And then my minion of crowds defeated him. And these are people who are not all lawyers. In fact, one of our top predictors, a guy named Jacob, he's an actuary in Brooklyn, right? Never went to law school. He's a savant. We have people say political science, philosophy, different walks of life, and they bring with them different insights that one expert can't possibly have. So if you learn nothing else from me today, it's the wisdom of the crowds allows you to have more accurate predictions, right, than any one expert. So as our market stands now, we can log on today and see how we predict the outcome in any given case. And we've had some pretty high-profile marketplaces. We've had healthcare prediction with the Affordable Care Act cases, right? We can actually track after oral argument how the predictions shift. Most of our players only predict after oral argument. Unfortunately, or fortunately, we actually predicted that the court would uphold the Obamacare mandate, much to my personal disappointment, because I wrote a book about it, but the markets are always right. Not always, but almost always right. And in later cases, we predicted once again that Obamacare survives. Okay, enough politics, right? And more Obamacare, right? Okay. We also do something that is somewhat novel. We don't just tell you if a judge will affirm or reverse. We give you what's called a confidence interval, right? We tell you how certain are we that a judge will rule in a certain way in a given case. We have a color coded. The darker the color, that's darker red or darker green, means we're really certain. If it's a more faint green or more faint red, it means we're not exactly certain. So over here, if you can see up top, 86% John Robertson reverse, solid. But here, 65% reverse, a little bit more faint. We can actually tell you with certainty. And the beauty of our model, you can test us. At the end of the year, you say, Josh, you were right, or Josh, you screwed up. We make our results public, everything's open source, our code's on GitHub, you can download it today and mess with it. We want this to be a public experiment for the world. But this only talks about one aspect of prediction markets, that is using crowds. The next evolution isn't only looking at crowds. It's what we call a hybrid. Okay, there are three types of predictions, three types. Experts, that is you go to the Supreme Court bar and practitioners. Crowds, right? The wisdom of the crowds, and algorithms, computers. So some may say, you know, experts shouldn't be afraid because they're better than crowds and algorithms. And maybe crowds say, you know, we don't need experts, we have the crowds. But the next evolution is a hybrid approach that combines the expertise of experts, crowds, and algorithms, and learns in what cases are experts better, in what kind of cases are crowds better, and in what kind of cases are algorithms better. And you create what's called an ensemble. You merge them all together. And this is the key, right? This is how you actually figure out what a prediction is worth. So Dan, Mike, and I have spent several years mapping the predictions of the Supreme Court. And we're not just talking about a single year, a single term. We're not even talking about a single decade. we're talking about 2 centuries. We have prediction data of the US Supreme Court going back to the Marshall Court in 1816. And we took a sample of 200 years of Supreme Court cases, 2 centuries. And over that time, you have almost 250,000 votes by justices. And you have outcomes in nearly 30,000 cases. Now you say, Josh, why on earth do I care what the Supreme Court did in 1816? How does that affect today? Let me explain this to you. When you're building a model, right? When you're building a model, you want the model to be what's called generalized. That you can stop in at any point in time and figure out what's going to happen here. If you build a model that only works in 2015, guess what? Scalia's gone, Gorsuch is here. Kennedy might retire and be replaced. Your model's worth garbage. It's not worth anything. This is why the Supreme Court forecasting project was tied to a specific composition of the court. The benefit of our model is that it's not tied to any specific composition of the court. That no matter who's appointed, who leaves, we're there. So our model will work today. It works 20 years ago. It works 20 years from now. Now you might say, wait a minute, Josh. We know how cases turned out 100 years ago. You can't predict something that already happened. But we actually can. What we actually do is pretend we don't know the outcome of a case. On any given day in the 1800s, we say, okay, we walk the Supreme Court this day, knowing what's known now, what will the court do? We make all our predictions with a veil of ignorance. We don't know what happens after we blind ourselves to it, and we can show our accuracy. So we have this model that predicts 200 years of cases, 250,000 votes from individual justices, and 30,000 cases, right? This is almost the entire US reports, right? It fills a library. So we're talking about 60 years. 60 years. Now, why 60 years? We start primarily with the Warren Court for the discussion today. This is more or less the beginning of the modern Supreme Court. And I'll talk mostly about the last 60 years today. So we have the Warren Court, we have the Berger Court, we have the Rehnquist Court, we have the Roberts Court. Oh, this picture's out of date. I gotta add some new pictures. We have Justice Gorsuch in it now, right? We have these new courts. And we focus on 32 justices. These are justices appointed by different presidents in different decades with very different ideological spectrums. And we have 12 presidents. Oh, I need to add Trump to this now. 13 presidents, right? And we're going to focus today on 7,700 opinions. This is enough to fill almost 200 volumes of the US reports. So how do we do with this sample? Almost a 70% accuracy rate for case outcomes. This is, again, year over year, 70% accuracy. Now let me explain to you what this means. This doesn't mean that in any given year we're 70% accurate, right? Sometimes it goes up, sometimes it goes down. Up, down, up, down, up, down. And when you draw a smooth line, it's at roughly 70%. This is why trying to predict any given year is very tough. You don't know what's going to happen in a given year. Sometimes the court reverses more often than not. Sometimes they affirm more often than not. You don't know in advance. And the value of our methodology, our algorithm, is it doesn't matter what year you're in. Because we know year over year, we right around 70% accuracy. You know, we have a really bad year here, like 50%, and we'll have a great year, we'll have like almost 80-something%, right? But we'll even out along the way. And this also reveals certain insights about specific voting records, right? We all know about the 5-4 cases. These are the hardest to predict, right? The 5-4 affirm and the 5-4 reverse. If you notice, there's a lot of noise here. It goes up and down and up and down. Up and down, up and down, up and down, right? But then you have a case that you might not think about, the 9-0 reverse. Look how smooth that is, right? Believe it or not, the most common voting pattern in the Supreme Court is a 9-0 reverse. You only hear in the news about the 5-4s, right? But the most common pattern is a 9-0 reverse where they all agree. Actually, the most bizarre is this one, the 9-0 affirm. This one throws us for a loop because generally the court takes a case to reverse if they all agree something's very up. But all in all, we can draw smooth lines and get these with some accuracy, despite the outcome. Now, not only do we have a 70% accuracy for cases, we also have a 70% accuracy for justice level predictions. What does that mean? How will given justice vote in a case? And this is a very important number, because it's enough to say the outcome of the case by how one justice voted. For this, we built what's called a heat map, right? What the heck is a heat map? We plotted each justice in the court and give them a shaded box. The more green the cell, the more predictable the justice is. What do you mean, Josh? A justice whose cell is very green means we are confident we can predict him. A justice who's kind of like this orange shade means we can't predict them. So what does this look like? I picked here 3 of the more, call them swing voting justices, right? Justices who historically were hard to predict. Frankfurter, Harlan, and Powell. You can see that they have various shades of brown, right? They're not all green, because they were fairly hard to predict. Likewise, Justice Sandra Day O'Connor and Justice Kennedy, they're moderate to swing votes. They have a lot more brown, not so much green. They're harder to predict. But then we move on to the people at the polls, right? You have Justice Brennan and Justice Marshall, very liberal. Justice Thomas, very conservative. And you see they have a lot more green in them. That is, they're easier to predict. That you can say with some certainty how Justice Marshall will vote. You can predict with certainty how Justice Brennan will vote. You can predict with certainty how Justice Thomas will vote. But you can't do the same for Justices O'Connor and Kennedy. And this is an important insight. Our method also lets you test an evolution of a justice, right? How they change over time. So one example is Justice John Paul Stevens. He was appointed by President Ford, Republican. And in the earlier years, he has a little bit more brown, right? Somewhat, harder to predict. But as time goes on, it gets greener. And that's a reflection of the fact that he became more consistently liberal and had an easier predictability rate. Same for Justice Rehnquist. He was appointed by President Nixon in '72 and served for 14 years. Then in '86, President Reagan elevated him to be Chief Justice. And as an Associate Justice, he was a solid conservative. He was green. He was fairly predictable. But as Chief Justice, he became a little bit more moderate, more towards the center, more brown, harder to predict. So you can actually use our model to track how predictable a justice was. Now, how does this work, right? What's the magic sauce? It's a concept known as extremely randomized trees. What the heck is that? Okay? Trial and error with what's called machine learning. Our model generates many decision trees that try to predict the outcome of cases. Okay? Some of these models work, some of these models don't. The ones that work, we keep. The ones that don't work, we destroy them. And repeat this many and many times to figure out which models are more accurate. And by running this test thousands and thousands of times, we say, okay, this is the best way of approaching it. We don't know which one will work, right? We have these random trees. We stick with what works, we throw what doesn't work. And with this, we can actually develop a model that's fairly sophisticated and accurate. Now, at some point, someone starts asking me, Josh, what information are you using? Now again, the justices, they're not on Facebook, right? They're not sharing, what kind of cat they like on Facebook and what they like. But we do know variables, right? For any given case, we can code them. So for example, pick a case out of the blue. What Court of Appeals decided it? That's a variable. What is the case about? It's a variable. Who is the petitioner? Variable. Who is the respondent? Another variable. What is the ideological direction of the lower court? Right? What is the current composition of the court? All in all, there are about 90 different variables we consider for each case. And with our trees, we decide how much to weight each variable. And we can develop a predictive power based on these approaches. Okay? And we put this to the test, right? We run a tournament. In the same spirit of Garry Kasparov versus Deep Blue with chess, in the same spirit as IBM's Watson on Jeopardy, where he played against Ken Jennings and beat him. And this is currently a product my colleagues and I at Lex Predict have developed, and our algorithm, we call it Marshall Plus, right? You like that, huh? Because it's not just about crowds, it's not just about algorithms, it's not just about experts. It's about combining the resources of all three sources. Okay? We have to keep in mind, this is not man versus machine, right? We're not trying to have Terminator here fighting. It's about man plus machine, if you will, if Michelangelo could reimagine it. Now you might be asking, Josh, why is this relevant, right? Why do we need this? Why are we learning about this, right? Who cares about the Supreme Court? How does this affect me? Well, let me tell you about this, guys. There's something called litigation finance. Oh, here's Perk. Good. If you want to bring a court case, you generally have to pay a lawyer. Drop down a retainer, or maybe take in a contingency. How does a lawyer decide to take a case? Well, this might pay off, be worth a contingency. I don't charge them up front, but I get a percentage of the payout. Now, there's a lot of lawsuits that simply can't be brought because there's no willingness. It's expensive. But what if you could know with certainty that this lawsuit has a 75% chance of yielding a verdict of $10 million? Oh. And what if you're a lawyer? You say, I ran your case through my Marshall Plus system. I got a pretty good shot at making a payout. Contingency, I'll take it. Oh. Take it one step further. Let's say you're a bank or a financial institution, and you say, we want to do some investing, right? We can invest in real estate, right? We can invest in stocks and bonds, or we can invest in litigation. And if we pay this lawyer's fees to bring this case, we understand that we might get a cut of the outcome. So prediction technology, not just at the Supreme Court, but also in the lower courts, has the potential to change how litigation operates. Because now you can have outside funding litigation. It works on the defense side as well. Let's say a company gets sued, Allstate, right, an insurance claim, whatever it happens to be. And their computer says, wow, we're going to lose this case, let's settle it. Oh, you just saved litigation. Already, insurance companies are using this sort of technology to ascertain their level of risk. Is this something worth litigating? Should we try to settle it out? Maybe farm it out to outside counsel? Or maybe let's go to court, right? It gets even better. What if you're assigned to a given judge? You ask, well, how will this judge rule? Okay, you can go about this a couple different ways. You can say, hey, local counsel, you guys know this judge, how's he going to rule? He says, well, I've been in front of for 5 cases, and here's what's happened in these 5 cases, right? It's pure speculation. You go to Marshall Plus, say, okay, he's had 15,000 decisions in his career, I've studied all of them. And in a patent case, where the plaintiff is a corporation of a certain size, and it's brought in this venue, there's a 75% chance he rules for the defendant. Whoa. What if you can change venue? You say, maybe I don't want this judge. Roll the dice, go to a different venue. Another venue might be more favorable, right? Lawyers do this already, but it's based only on their own sense of what is right and what's wrong, right? They don't have any data-backed science. They are the proverbial experts. So when you combine the experts with the algorithm, you get to a more precise answer. Now this leads to something that I have been calling for years robot esquire, right? Imagine this, you walk into an office, you want legal services, and you talk to a robot. It's not science fiction, right? You're still gonna have a human being at the front, but you're gonna have some legal decisions in the back. And I wanna raise a few issues that you should think about. I don't have an answer for them, right? But imagine we develop an algorithm that's so accurate, right? It can develop court decisions with a 90% accuracy. Let's say we have 90%. And then you have a judge. And the judge says, well, shucks, I want to do X, but the computer says to do Y. I once presented this paper at a conference a couple years ago, and I told a judge. And I told the judge, you know, we can probably predict your judgments within a pretty good degree of accuracy. No, you can't, right? I'll do the opposite of whatever you say. Whoa, right? Think of that for a second, right? So then your judges will start rebelling. But you already see this. There are certain jurisdictions that allow computers to engage in adjudication. Really? Parking tickets, right? I'll give you a really easy example. Let's say you get a parking ticket, but you had prepaid for the parking on your phone. They have these apps, right? And you can show with accuracy that you had paid for that spot on your phone and that the guy who wrote the ticket made a mistake. There are some jurisdictions where you can just contest it online. Submit your proof of purchase and say, okay, we're going to waive the ticket. You might say, oh, that's great, Josh, right? I don't have to go to court, I can get it waived. But think about it for 1 minute. A computer is now adjudicating your criminal record, right? It's a traffic ticket, right? You know, it's pittance, right? $20, $50. But you're letting a computer engage that. About a different context. Sentencing guidelines, right? In some jurisdictions, your sentence is based on a formula. And that formula is calculated based on some Marshall-like algorithm, right? The amount of time a person spends in jail, that is, their liberties being deprived, is determined. The judge signs off on it, but it's basically done by a computer. Bail, right? There are jurisdictions that have formulas for how much bail is to be released from prison. And that's based on an algorithm. Now, Mr. Zuckerberg was there today. I don't think he revealed his source code. Did he say he was going to show his source code? No, I don't think so. No, he wouldn't. So when you have these various algorithms determining how much bail a person pays, or might be calculating sentencing guidelines, it's a black box. What do we mean a black box? We don't know what's going on inside. You know what the inputs are? You know what the outputs are? But you don't know what the special sauce is. This is why we put our code online. We're very honest about this. We care much about this because there's a lot of potential for abuse. But when you have this data and you don't know what's going on online, there's serious risk. There's serious grounds for problems that can arise. Okay. One final point, and I'll turn to Professor Ikes in a minute. I had this premonition years ago when I started running fancy SCOTUS that one day, you know, imagine Justice Kennedy wakes up in the morning and his breakfast doesn't taste very good. He goes like, you know, how do I roll in this case? Let me check the crowds, right? We often think that judges rule based on popular opinion. Judges can't run polls. We have something that looks a lot like it. And what kind of world are we living in, right? Just think of this for a minute. What kind of world are we living in where courts will start to actually consider what crowds think in making their decisions? Do we actually want that? Do we like empathy? Judges being independent? Or do we want accuracy? These are hard, deep questions. You know, you have these questions about self-driving cars, the so-called trolley problem. You've read about this, right? Where if you have an autonomous car going down the road, right, as a choice, it can swerve right into a trolley and kill everyone in the trolley, or swerve left, hit a little kid and kill one person, right? If you're human, you know, I don't know how you make that choice. You make a decision. But with a program, you actually have to instruct it what to do. If there's a choice of killing one person or 10 persons, which path do you take? So predicting the behavior of the Supreme Court is a good, entry. It's a good starting point for this discussion. But there are ethical issues here that I am thinking about very deeply for many years, and I'll be happy to talk with all of you about later. But these are things which we should be very, very careful about. Thank you all so much, Mr. Ikes. I welcome your.
So please join me up here.
Perfect.
This is to be a conversation.
Oh, good idea. I love that. Yeah. Knocked out my charger. Put it back up here. Okay. We have wireless charging cables for laptops and more business.
So you ended with with the place that perhaps because of my experience here I started with, which is an eye towards the ethical implications of this kind of technology on our jurisprudence. And I'd love to hear you address that and talk about it a little bit.
Oh crap, my charger just broke. Okay, I have to get that later. This is not good. Speaking of technology, the machine's fighting back on me with this one. Oh boy, this is not good. Okay. So I think the short answer, right? The short answer is that technology often moves faster than law. And very often lawyers aren't in the right room, so to speak, where it happens. That when you can build these really sophisticated algorithms, you're thinking of what you can do, not whether you should do it. I have had a number of conversations over the years with technologists on how to perhaps slow down this process. Now, I'll give you a very easy example. You're probably familiar in the law with the concept of unauthorized practice of law, UPL, right? You've heard about this. This practice, I think, makes general sense. You don't want non-lawyers providing legal services because they might give bad advice, right? If you're a charlatan, if you advise someone to make a transaction that's against the law, it might be voided and the person loses their money. But then you have a simple thing like the LegalZoom, like the LegalZoom, right? This is a company that provides legal services, but it's not a law firm. And they've been involved in litigation in a number of states, arguing, are they actually engaged in the practice of law or not? And you might say, well, it's great to have a LegalZoom. It's a technology firm, lets people make easy to understand wills. And then you might say, actually, let me rotate the camera really quick. The camera's framed. This is why I'm professional, right? It's got it plenty. And then you have one side that says, well, you know, you should be able to, what do you call it? You should be able to have a will that's cheap. And the other side says, well, if you have a will that's cheap and it's not reviewed by a lawyer, the person dies and their estate's in disarray. Right? So these are legitimate concerns on both sides of the issue. But then you move a little bit forward to this, right? You think not only about a LegalZoom, like a very simple product, but something far more sophisticated, like legal analytics, where you have these various firms that are advising Fortune 500 companies saying, here's how courts can resolve the case. That looks a lot like legal services to me. And I don't think the state bars have cracked down on these companies yet. I think they will. I told them they probably will. Because lawyers don't like competition. And they find that non-lawyers providing legal services, they'll intervene. So, you know, is there a difference between Lexis and Westlaw, passive research tools, versus something that actively and aggressively predicts the outcome of cases? Is there a difference? Maybe there is.
So in line with that, if you were going to amend the model rules to be either more broad or more narrow in consideration of technology, what would you do? How would you do it?
What a good question. I think the one model that I actually like is to give a nurse practitioner, right? So, you know, with medical doctors, different degrees, right? A doctor can do X, a nurse practitioner can do a little bit less than X, and a nurse can do less than that, right? Both lawyers, it's a one-size-fits-all solution. So I like the idea of having different grades and maybe having legal technology analysts that could do certain types of advising work for short of actual legal services might be a good niche to include this. What do you think, Jeannie? You know where
I'm being quiet.
Oh, okay.
And I guess for the UPL, it's my opinion that needs the most work. And I strongly believe that the economy is going to actually leave the lawyers behind in this.
You think so?
Yeah, I do. And once there's too much economic power in alternative legal services that aren't provided by lawyers, that's when we're going to see a shift away from the empowerment of the bar to regulate. So the alternative I see in UPL certainly is expanding the tent, you know, and
right.
bringing more people in. Otherwise, we lose the power to say what is professionalism, what are good legal services, and how do we protect the
Yeah, I
client.
think that's right. That's right.
So that would be my spin on UPL. Are there downsides to predicting?
Yeah.
What the outcome of, there are so many venue shopping problems that I see with this kind of technology. In addition to, I hear people talk about this gravitation towards the mean and what that means if the judges are sort of predicting their own behavior in some way.
Yeah, this is what I alluded to earlier. You know, imagine this, right? Let's just say there's the middle district of Podunk, I'll make up a district, right? And computers say that judges in this district always rule in a certain way. And judges see that, and they're like, oh wow, maybe I'm doing something wrong. Not because they're getting reversed by a higher court, but they're outside the mean. They're not normal in terms of the regression. And I don't know how they feel that judges are trying to modify their behavior to respond to technology. It's a bit unsettling, but you know it's going to happen, right? And let's use an example you're familiar with, right? Sports, referees, NFL. After any given Sunday, they have reviews of the refereeing. And if they find that some judge is making a lot of bad calls, they have a talk with them, right? And they use data, these instant replay, they use these various modes to assess how a judge is behaving. Usually a judge only learns if he made a mistake if it's reversed by a higher court. But now we can say, aha, Judge X made a ruling that's 85% out of the mainstream. And I don't know, it's weird. It makes you feel unsettled.
Do you think there's an impact for the kinds of societal leaps that we're taking? So let me explain this. The abolition of slavery is a perfect example. That was out of the mainstream thinking. So how are the ideas as we evolve as a society and culture going to be represented in our jurisprudence if we're constantly moving to the mean?
Yeah, and this is a point I often make to law students. The reason why you're in law school is because you're being trained to think in a certain fashion. If your entire job is copying and pasting old form books and reusing them, then we don't ever get new ideas, like abolition, for example. There is a creative spark that computers will never, ever, ever replicate, and I mean that sincerely. But if more legal litigation is channeled towards algorithms, you do lose some dynamic aspect to it. And that could retard the profession, I think, in a negative way.
So tell us when robo-judges will happen.
Oh God. So here I'll put my
And that's by the way my cheesy populist question.
Yeah, I'll put my constitutional law professor hat on for a minute. I mean, there's something called the due process of law, and I think there are really credible issues. Does computer provide the due process of law? And I raised the example of the traffic ticket computers. You know, people aren't objecting to them. I think if they want, they can opt out and go to an actual traffic court and sit in line for 8 hours and get their ticket taken care of. But you can imagine as a cost-saving mechanism, someone said this is the only form for resolution, right? You have to start here and then appeal de novo, perhaps, to a human flesh judge. That's problematic. Where you might see this even more precisely is in things like hiring, for example. Various algorithms of who gets hired, how you rank people. We have credit scores. We have a lot of robo-judging that exists now that's largely invisible to people. But many aspects of how our society functions are algorithmically defined.
There are certainly places in, particularly in Silicon Valley in California, where HR professionals were asking for Facebook passwords to do a fitness and a match test for the individual in the employment opportunities. So it already, as you said, it's out there and it's happening. As we move towards judges being able to look at themselves and see themselves reflected or not in the predictive modeling, aren't we getting closer to robo-judge, whether we want to or not? And this middle person in the middle, when they start passing the computer's prediction over to the defendant, how does that differ from directly robo-judge?
Yeah, so Rose, you're going to lose this case 80%. You should probably not bring it or settle out, right?
So it changes what it is to be a lawyer.
I think that's the way of putting it, right? If you know that your case has an 80% chance of losing, you might not bring the case. or if you're on the defendant's side, you might settle it out. But these are conversations lawyers have every day, right? Do I settle it or go to trial? And it's usually based on the lawyer's gut instinct, which is good. You need experience. But also the flip side is, algorithms aren't always right. You can be 70% certain, and there's a 30% chance you're wrong. And you don't know that because you went to settle, you didn't try it out. So it could, I think at a minimum, this would probably reduce the amount of litigation that would occur. And then there's a second order problem. If people start adhering to these algorithms, the self-fulfilling prophecy, right? That you're stuck mired in the past, you're cemented in the past, and then you don't have the variability to actually develop going forward. So it has potential to even reduce litigation bill non altogether.
So what is the role of the lawyer in this new world where there are so many predictive tools that are in some ways maybe doing the thinking and the strategizing for us?
Dan and I make this point very bluntly as hard as we can, and Mike as well. Lawyers are not being replaced. I think they need to adapt. I think people like, so good enough, so I'm teaching you things that are novel. Dan's teaching a class on blockchain at Chicago Camp, right? Everyone knows what blockchain is, right? You might have heard of Bitcoin and cryptocurrency. Blockchain, as a general matter, is a way of recording transactions in a distributed fashion. You're having banks now using blockchain to record financial transactions. And the benefit of a blockchain is it's open, it's transparent, it's not in some sort of closed universe, right? And you can restrict how much is going there. I think lawyers have an obligation to at least be familiar with these topics as they're going out into the world. So at the bar, does the Vermont bar have any minimum requirements for literacy of computers? Is there anything in the Vermont bar? Computer data security, privacy? I don't know the answer. People are, yes, what are the, what they require?
What's the minimum tech competency requirement look like?
Minimum? I know that it actually says in a rule that you have to have a tech competency. I don't know the number.
Is it the model rules or the Vermont rules?
Yeah, the model rules.
It's in the comment to the model.
And also
rules.
the state rules, actually.
What I do know is the Vermont Bar Council, Mike Kennedy, is extremely active in this area and very forward thinking. So the decisions that come from Bar Council are very on point and not as progressive in how to think about these things.
Yeah, I mean, one thing that comes up in a lot of states is data security, right? How are you storing your data? You keep it on a thumb drive in your pocket, right? You keep it on your laptop that can get stolen. Is there encryption? How many layers? Even something that's client confidences, right? Because if you don't secure your files, not only is your stuff gone, your client's confidences are gone, right? What if you have information on your computer about paying bribes about Access Hollywood and Stormy Daniels and all that stuff, right? You gotta keep that safe. Let's say Michael Cohen
goes away.
Let's say Michael Cohen has some encryption. That'd be a fun turn of events, right?
Ooh.
Michael Cohen's files are encrypted, turning over password.
Biometrically
I want
keyed
to do a body part.
encryption. How about that?
Yep.
Can the police force him to put his
Yeah,
thumb on?
there's cases on this, but self-incrimination is a very thing.
Absolutely.
Mr. Randa?
Can we ask questions?
Please ask questions.
One of my concerns is about sentencing and using algorithms to come up with sentencing, for the judges to use that as a platform to make sentencing decisions. Now, the thing, like, we're talking about algorithms, but there's also a bias in the data that's going into those algorithms. Yeah. And that's one of my biggest concerns is that data that reflects racial bias or community bias and location and cities. And that's being infiltrated in the systems that they're discussing actually doing. And not far from now, they're getting close to, because there's such a disparity between judges of sentencing. And you can go into any court and have a different sentencing one day and have a different one for the same thing the next day. So my concern, one of them, is there, and specifically there, because I feel like a human being has more empathy than a computer, and trying to put that into an algorithm, that's something that's really missing.
I'll
Please,
take it.
please,
Just,
please.
I'm going to refer to a colleague of ours, Professor Judson at Loyola College. He and his students put together an app for their judges to recommend sentencing alternatives. And I'm giving this back to you so you can understand how, when there's a different perspective, it can actually head the sentencing in a different direction and away from what you fear. So in the New Orleans parish where he has been trying this out, his students created this app, and it recommends, it shows the judge the cost difference between incarceration and all kinds of different restorative justice types of approaches. Depending on the case, there's different approaches the judge could order. And time again, and then it predicts recidivism based on those different pathways. And it is more cost effective not to incarcerate, and the risk of recidivism is lower if they don't incarcerate. It always shows these alternative restorative justice approaches to be the better option. And their incarceration rate has gone down for juveniles with the judges that are using those apps. So this is a long way around saying the statistics and the algorithms reflect the individuals that created that algorithm. And so sometimes you have a good judge on the bench and sometimes you don't. Sometimes you have a good algorithm and sometimes you don't. And there always has to be an appeals process for that, right? Why don't you?
Let me give a brief insight. So it's often said a judge's ruling is based when you have for breakfast. It might be based when you have for lunch. So I read one study that compares sentencing times based on the time of day. And this is serious. If you ever are going to be sentenced to a crime, you want to be sentenced right after lunch.
It's a wonderful NPR
Because the judge is satiated, right? He had his meal, he's feeling good. The worst time is before lunch, because he's ready to get out of there. And you know, you think this is insane. But you know, think about it. If you ever about to get lunch, like, all right, this class over yet, right? You're back to lunch, oh man, I'm feeling good. So there's a lot of human empathy that can go both ways, depending what you had for lunch. I saw hands over. If you want to call people, please.
Yeah, I don't know your name. If you could do your name, that would help me.
Welcome to stand for the hands, guys.
Sure.
Do your thing.
My name's Nico. I'm a 2L here, and I'm over here. But I'm curious about this crowd. Is if it's a specific crowd, or if anyone is welcome to join, or if you have like data collected on the demographics of the people who are predicting that are part of the Marshall algorithm.
It's a good question. So how do you compose the crowd? Well, we have different mechanisms. There are a lot of law students. We have a lot of lawyers and a lot of non-lawyers. We've done polling about who these people are. They come from a pretty wide range of backgrounds. But what's unique about Fantasy SCOTUS is we're not recruiting people. We really don't have much advertising at all. And these people who are self-selected, I mean, they're people interested in the courts. This is one market where having people with some interest in the court is a good thing to start with. And it's hard to get people with no interest in the court to waste their time doing this. So I think we have a pretty good range of perspectives. And the other variable we have is continuity. If someone comes and plays 1 year, they don't have a track record. But if someone's been playing for 7 or 8 years, they have a track record, and we can either weight their average more or less depending on what the track record is.
We'll go Frank, Chloe, Vic.
Yeah, so more on your algorithm proposal. So you pitched this idea to us that you're using a computer logic system as well as people that are actively participating in cases that are up for trial. Now, this seems like to me an idea that you'd want to be pitching to like Lexis or Westlaw and incorporating that as like the Shepherdize or fantasize the case or whatever. But how would you continuously keep people putting data into your system without any incentive or marketing ploy? How does that continue to function in a world where, you know, lawyers will realize we don't want robo-judge, we want to be the judge? How do you keep like a system like that functioning?
I alluded to this earlier. I think once the lawyers figure out what we're doing, they're going to be very mad.
Yeah. I can see
Now it's like a cute novelty thing, whatever it's fancy. But when they recognize what this potential is, they're trying to shut it down.
Because Zuckerberg taking the information without asking, where
Yeah.
you're not even asking nicely, and people are just.
We don't need it. The dockets are available publicly. I mean, the federal court dockets, they charge you for it, but the data's there if you want it. The briefs are publicly filed. You can scan them, right? The transcripts of arguments are available. You can read them. Machine language to review them. So these sorts of tech companies don't need the permission of the bar until they need the permission of the bar. I suspect, I had a conversation with the chief evangelist officer of a pretty big company, I won't say which one, and I told him that 5 years ago, you need a legal opinion on this. I think you're gonna shut down at some point with UPL. I'm convinced this will happen at some point. Once the entrenched interests recognize the threat of competition, they'll use what all monopolies do, they'll use the cartel power to shut down. It'll happen eventually, I don't know when. They did to LegalZoom, they've done it in a number of states. LegalZoom can operate, what, in a couple states now? I think it varies.
Avo got the whack.
Yeah, Avo got it.
LegalZoom, LegalZoom is still operating.
In every state? Okay.
I think so.
Okay, Avo, okay, but it's coming.
So, my question was, can you think off the top of your head right now of any implicit social biases that you've noticed from the crowdsourced predictions you've collected on Fantasy SCOTUS? And if so, do you see that as a mechanism we can use to kind of rid society of their implicit biases?
Whoa, social bias implicit. I'll be honest, I haven't given that any thought. Do you have anything you'd like to speculate that what we might find? I haven't given this any thought at all.
Well, like with the sentencing algorithms, we see obviously that African Americans, poor individuals, individuals who live in, impoverished communities, individuals who have one parent, individuals who maybe have a limited education. So we see already these biases are attacking specific individuals. And I guess my question is, since we see these biases, do you think there's potential for us to use the data you're collecting to unveil to the public what it is that they are biased about? Everyone says, no, I'm not racist, but...
Well, let me answer your question in a far more innocuous fashion, right? Instead of implicit bias, let's look at specialization in different areas. But we do find that certain people might be better in, say, tax cases, and other people better in constitutional law cases. And what's actually useful is figuring out how to weight certain people based on their level of expertise and their past performance. So that's entirely non-responsive to your question, but it does address the fact that you can build profiles of what people have done in the past, what they'll do in the future. And I'm sure we can figure this out. Along a question I haven't given it any thought. Thank you for that.
Right. So do you think your app could be extended or could it be evolved to incorporate, maybe predict the political makeup of the Supreme Court in case there's a vacancy? For example, a variable X could be the election between two candidates in the Republican and Democratic Party. Variable Y could incorporate how the Senate and the House have ruled over the, have appointed or approved or denied Supreme Court appointments from either side. So do you think in the future, if we have all of the raw data, do you think it can be used to predict the conservative or liberal makeup of the Supreme Court?
Oh, I'll give you one better. After Justice Scalia passed away and President Trump was elected, we launched we called Fantasy Justice, where we took crowdsourcing data on who would be selected. And let me tell you something. Our model picked Neil Gorsuch long before anyone else did, right? And there are a lot of reasons why. We can speculate why that is. I have my own theories. I can shed some light. But our model looked at Gorsuch very quickly. And if you recall, there were two lists that President Trump released, the first list and the second list. Gorsuch wasn't on the first list, he was on the second list. And people on our network were able to predict. Now, my suspicion is Justice Gorsuch was picked in large part because his clerks are very aggressive and they're very active. And there were bots who were flooding our site with votes from Asia for Neil Gorsuch.
Wow.
Yeah, I haven't made that completely, but I'll be online now, whatever. But we had, yeah, everything's, I was going to write about it, I forgot, so now, happy anniversary, 1 year anniversary, bots. But they were basically, so we had, a way you can vote online, and we required IP anonymized, meaning if you have the same IP address, you can't vote multiple times. So to get around that, you can have what are called bots, which is basically you take over someone's IP address and you use them to vote. So we sent a flood of data from, was it South Korea or was it the Philippines? I'm drawing a blank in the country. But it was a country somewhere in Asia where people were just flooding in IPs to vote for Neil Gorsuch.
So take that a step further. When you hack the crowd,
yeah.
do you hack the result?
Yeah. So this happened during the election of 2008. where there was a primary, and the Ron Paul, remember him? The Ron Paul fans, it's happening, right? The Ron Paul fans basically tried to flood a prediction market, the Iowa electronics market, and basically flooded all these fake contracts to try and give Paul a surge. So we're attuned to how to root out people trying to hack the results, because if you can hack a prediction market, you can change perception. And I had this bizarre premonition that, man, maybe Donald Trump will wake up and look at Fantasy SCOTUS and say, oh, who did I pick today, right? For the Supreme Court. I had this, I doubt it happened, right? But, these things do matter.
If you tweeted it, it would have mattered.
And I did tweet it. And let me put it this way: there is, there's lobbying that goes on among people who want to be in the Supreme Court. There's lobbying, and they care about these marketplaces. They follow them. I know they do.
So I was going to ask, how do you prevent bots from swaying the votes? But I'll add to my second train of thought on the same matter, which is that I just went to sign up to see what it was like, and it offered the option of signing up with Facebook. So I wonder if you're at all in conversations with Zuckerberg to talk about like how to mine data and personalities.
We're not doing that. Maybe we should, but we're not doing that. Maybe we should disable that sign-up feature. I didn't
You should probably do that. Maybe.
Yeah, I
It's
didn't
not
like
it's up today.
Was it?
Give it some time.
Well, I forgot we do the Facebook sign. Maybe we'll think about disabling that. We don't use it. Well, at one point we wanted to do a system where people could like make Facebook groups with their friends and like play against their friends, and it's so complicated. It's really expensive to build these things. We just forget it. All right. Albert, where's your hand up?
Yes, just two things. One, to disagree a bit with the Bar Association to shut it down. I think the Uber example suggests that once you get these out to a certain point, they can try.
Yeah.
And my own take, whatever it's worth, is that the current rules are essentially separating lawyers from the tech rather than the other way around. And that the current rules are essentially serving to leave the lawyers behind as this goes forward, the preventing the kind of collaboration that would allow lawyers to evolve into the system, freezing them in the old system.
Yeah.
So whatever it's worth, I think that they're actually completely self-defeating these efforts.
That's what I meant by economic weight.
Yeah.
You're probably right. Yeah, there's a critical mass. Once you hit it, you can't stop.
The companies will not be run by lawyers because the lawyers have been told they're not supposed to. Second piece, if I may just advertise very briefly for the company that I'm involved with, which is called SCOTUS Labs, which does somewhat similar prediction around legislative enactments, and will soon add regulatory processes as well. And it is the mix of data that you bring in is a very important and interesting element. I know you guys, in addition to your own prediction, when you run into the algorithms are picking up all kinds of different data points. And to go to your point, basically all of these AIs train against something. And if you train them against something that has embedded bias and mistake or whatever it is in it, then they will emulate that. And if you train them against things which don't, then they'll emulate that. And so it's not the AI itself is predisposed to bias. It is just predisposed to emulate the thing it's been trained against. Keep that in mind as a design principle. I don't think it means we shouldn't have AI. It just means we need to know what we're doing when we deploy it.
And it calls for the scientific method, right? And how you approach it, and how you choose your data sets, and where you see the most bias. It can be either in the data set itself in the content, or in the choosing of the data set. So there's two places where bias can enter.
Sorry, if anybody else wants to ask. You must have heard of Microst in New York City. It's an AI that's allowed, a firm in New York City is allowed to use an AI system for all their bankruptcy cases. So it's predicting bankruptcy cases. So the ABA, I gather, in New York allowed them to do that. And for the last 2 years, it's been predicting the outcomes of bankruptcy cases.
If I just correct one point, the rules are actually determined state by state, typically by the state Supreme Court, so it's not the ABA, it would be the Supreme Court of New York, which is the promulgator of the.
But yeah, and that's just one sector, and they started with bankruptcy because it's a little bit more predictable, industry, but, you know, they're allowing it there, and there's no pushback that's happening, and so, like you always say, we have to start adapting.
I haven't heard of that.
I guess I'll ask the last question unless anybody else has any other questions. Oh, we got one
You may
more.
have touched on it. I was kind of late to the party, I'm sorry. As aspiring attorneys with maybe 40 years in front of us, how do we prepare for this? Should we be learning coding? Should we be looking to get
Oh, I think there's a question from my dear colleague.
So yesterday, I spent a lovely day at Suffolk Law School with colleagues from across the United States talking about what the appropriate coding for lawyers course looks like to put in law schools and how we should be training lawyers. At Georgetown, they look at it as training lawyers to be developers and actually skip right over practicing law into software, because actually that's where you're going to see more clients, is their argument at Georgetown. And they're actually rewriting their curriculum around these concepts at the moment to help improve their ranking, just to give you an idea. And they're ranked 15th, and they want to move up to 14th because they created the top 14 and they got bumped out of it, and now they're upset about it. So Georgetown said that, not me. So yeah, there are all of these possibilities, right? So there's how to use technology in the practice of law, how technology is affecting the laws we write, how technology could be used in all of these other ways. So when I talk to our dean, I talk about the donut, right? And some people will fight me on this, right? And I talk about the hole. The hole is getting smaller, and that's the place where everybody raises a hand and says, Your Honor, okay? Where they sit for the bar, right? The hole is getting smaller. And that legal industry around the outside is getting larger. And you can look back at the Sandiford article and study that she did out of, I believe it was the Illinois bar. 82% of the people in the United States never use a lawyer in their lifetime. That is a huge untapped market. And the legal industry that's becoming the outside of the donut, those are the people that are addressing that market.
You should pitch some classes, automated systems, e-discovery. We got some.
And there's a lot of courses that you can take for this. So here you can take cybersecurity law, you can take e-lawyering, you can come hang out with the CLI folks when we do our gatherings every month. You can take apps for social justice during the summer. I'm teaching that this summer. You come in with an idea and you act as a lawyer entrepreneur with a stakeholder who is a licensed attorney. And you build an app that addresses a particular legal need. What else? I'm forgetting something. I teach e-practice management. Crystal took that course. So there's e-discovery and big data, and half of that is all of the things we were talking about here today.
All right, the last question is mine. All right, so I have a little hypo. So the prospective client walks into the law office and he says, I've been wronged, I have this issue, and I want to sue. I want to bring an action in court. The lawyer goes into his little software, types it in, and he says, I'm sorry, sir, based on the venue that we would have to sit in and the judge that would be overseeing this case, we have an 80% chance that we're going to lose. And he says, I'm sorry, I will not take your case because there's no way it can possibly win based on what my software said. And more than likely, every other law firm will tell him the exact same thing. Does that per se create a due process issue?
Well, it's not due process, it's private counsel, right? Private attorney is under no obligation to take a client. And you'll learn this in legal ethics, you don't have an obligation to take a client. It's a pretty important rule. I think your question is, what about the gambles, right? The long shot cases. you might have some, legal defense fund that's willing to take them, but you could have entire areas of the law crowded out that just it's not worth the money if you can say with certainty what's going to happen. And if that's the case, and you don't have this entire channel of cases going to court, then your data becomes crappy, right?
Well, and there's a stratification.
Yeah.
Right. So I'm going to turn that question around and throw the hypo back at you, Michael. Is there an ethical obligation to use such technology to let the client know before they spend their money on something that's fruitless?
Good question.
To notify them what their chances of winning are?
Good question.
I think, yeah, you have to definitely let them know, say your chances of winning are not good. But I think it kind of gets a little bit bumpy when every single lawyer will say, I'm not going to take your case for that reason, because your chances don't look good.
There's a contrarian strategy which often can drive, you'll find if it's a big enough market that there are 5 lawyers in it, and take all of those on just the theory that that's where their niche is. And if I've got a 20% chance of winning and I can figure out how to do that reasonably cost effectively, and I take all of those, I've just made a perfect.
I'll give you a more concrete one. Let's say the algorithm says settle, and you go to trial. Are you going to look for malpractice?
Well, that's exactly where I was going.
Anyway, it's a little bit glib to say that the contrarian thing, but actually, in the there's almost always an interesting counterplay to at least consider whenever you find one of those majoritarian
And
plays.
for those of you that follow e-discovery at all, Judge Peck is the judge that went out on a limb and said, if lawyers do not use computer-assisted review, and then they are potentially committing malpractice. And not only is it okay to do it, it's important to do it. And in the far end of the spectrum are the cases where you're committing malpractice if you don't. So.
Anything else?
Looks like Bish has a response.
Right, I was just going to extend it to the malpractice question. So let's get into a hypothetical. You have an 80% chance of winning your case based on the software, and for whatever reason the lawyer screws it up where it doesn't turn out the way it's supposed to turn out. It might be obvious that the client may sue the lawyer because saying, oh, it's 80%. So could the lawyer try to shift the liability to you guys, saying that?
This is one of the reasons why I'm very afraid of this industry, and I've shared this with my colleagues, and I tell people that you're now giving legal services, and if you're UPL, you can be sued for malpractice.
Yeah.
There's something I'm very worried about.
Right.
Giving bad advice, it's not just bad software advice, right? You're not just selling them a buggy app that crashes if rebooted. If you give bad legal tech advice and they lose $1 million judgment, they can come sue you. And let me put it this way, getting an insurance policy for one of these sorts of companies is very complicated. To actually figure out what a general liability insurance policy looks like. They don't know what this is. This is not a thing insurance companies know. I mean, we have one, right? But this is something that is very involved. It's a level of risk that insurance companies don't understand.
Right.
All right, well, let's go all sign up for Fantasy SCOTUS. And Chloe and Mira, stand up and give a bow to new co-chair. Say hello. You'll never see me again.